will be time challenged, given both those tasks, so I will make the PowerPoint presentations available so you can copy them later. So the evolution of victims' rights in Australia. To make this easier to understand, I have divided it into broad categories or decades. These are not precise. There are incidents or events or changes that happened. For example, I will talk about the 1960s, but some of those things may have happened early in the 1970s. But I have grouped the pointers that I want to make into those decades to make it easier for you to understand that evolution, which is my primary task. So let us begin. This is not my caveat. The underpinning comment that I will make is that this is not an academic theoretical presentation. This is an outline of the different things that happened, the different events, the different changes in policy, with some commentary. And you're welcome to ask questions when time is available during the breaks and the days that I'm here. So let us begin with the 1960s. So in Australia, the primary debate during the 1960s with respect or in relation to victims' rights was whether the state has an obligation to pay compensation to those people who are directly harmed by crime. And in particular, the parliaments of Australia talked about the innocent victims of violent crime, whatever that may mean. Now that debate was fueled by conversations and commentaries that were happening elsewhere in the world. And those conversations, those commentaries were fueled, they were encouraged by, among other people, the work of an English magistrate called Margaret Fry. And she argued initially that when a criminal court finds a suspect, an accused person guilty of an offence, then the punishment, the sanction, should address the harm that has been caused. And so she invited the policymakers to revisit the idea of restitution. That is where the offender makes good the harm that he or she has done. For example, by paying a sum of money to cover the medical costs of treating someone who they have assaulted. But Margaret discovered very quickly that the police are very good at capturing people who are impecunious, offenders who cannot afford to pay restitution. And so she turned to the state and suggested that they had some responsibility to assist their citizens when they are in distress. And that, in Western societies in particular, was a common theme, with the introduction, for example, of free education to people who could not afford to pay, or unemployment or social security benefits for people who lost their employment, or the provision of universal health for people who couldn't afford to pay. So this notion of assisting people who were somehow disadvantaged, and the notion of collective responsibility to help address that distress, helped inform some of the conversation around victim compensation. So in Australia, that debate resulted, for example, in my home state of South Australia, with the introduction of a state-funded compensation scheme in 1969. We were the third state of the 6 states of Australia to introduce such a scheme. And some other states didn't introduce state-funded compensation until the 1970s. One of the other issues that arose in at least academic conversations in the 1960s goes back to a point I made earlier about the parliaments of Australia referring to the innocent victims of violent crime. And that is, Niels Christie had put forward the notion of an ideal victim. So when you talk to the public at large, they have a often a preconceived idea about who is the victim, and therefore who is morally most deserved of getting assistance, such as access to compensation. And that is important in terms of the conversation that happened during the 1970s, for example, about violence against women, and issues such as rape in marriage, and the extent to which a female, who can be a male, who is raped in a marital situation is morally deserved of the same level of care as a person who might be raped in a public place. So that this idea of an ideal victim and moral deservedness is an important consideration, and it was reflected in many places around the world in some of the public policy allocations that were made. One of the other things that began to happen in Australia, but it was more common in other countries such as the United Kingdom and the United States, was the introduction of research, and in particular the gradual development of state-funded victim surveys. And now they're quite sophisticated surveys that are conducted in various places around the world. And what those surveys revealed is that the police are only aware of a small proportion of crime, and the proportion of crime that they are aware of is dependent on the nature of the offending itself. For instance, in my home state, only between 15 and 30% of sexual assault offences are known to the police. Yet, because insurance companies refuse to pay unless a property crime has been reported to the police, then between 80 and 90% of property crimes are known to the police. So there is a significant difference. And the research that began in the 60s informed us on the dark figure. Some people talk about the iceberg. The 1970s, well, piggybacking on the civil rights movement, the feminist movement in Australia began to challenge some of the preconceived ideas and some of the myths about violence against women in particular, but later about violence against children as well. And so we saw, for example, in several states of Australia, an interest in how to expand victim assistance beyond simply giving monetary compensation from the state to innocent victims of violence. In South Australia, for example, the first women's shelters were established in the 1970s. The first dedicated rape and sexual assault service was established in the 1970s. Both funded by government, or in women's shelters, a combination of government and money raised by non-government organisations. But also, in the late 1970s, mothers who were bereaved by murders, by homicide offences, gathered together and formed the Victim Support Service. They began to challenge the way that victims, particularly victims of violent crime, were treated by public officials in the criminal justice system. And so their activism paved the way for the development of self-help organisations such as the Victims of Crime Service, which in South Australia used to be called VOCS, V-O-C-S, which is Latin for voice, giving victims a voice in the process. The research, as I mentioned, in the 1960s began in the 1960s, continued in the 70s. And one of the things that research showed, but more particularly introduced, was a sense of rigour about whether or not what is being done to assist victims actually matches their needs. And we now know, after 2 or 3 decades of research, that much of what was offered in the early years under the auspices, under the umbrella of victim assistance, did not necessarily match the needs of victims of crime. One of the most significant studies in that era came out of the United States, which showed that after interviewing 1,000 victims and comparing their identified needs with the services that were offered by 200 of the so-called good practice victim assistance programs in the USA, that there was a statistically significant mismatch. And one of the reasons for that, according to the researchers, was the way in which victim services evolved as they became increasingly professionalised. And I'll say a little more about that in a wee moment. The 1980s. Well, this is an era that began with a number of inquiries into victims of crime. So the agitation, beginning with the women's movement and then others joining with that of the 1970s, caused governments in Australia to stand up and put victims of crime onto the political agenda. So in 1979, for example, both the Liberal Conservative and the Labor Democrat, the 2 major political parties in South Australia, went to the electorate promising to hold an inquiry into victims of crime. And similarly, through the 1980s, we saw that debate played out in pre-election promises in states, New South Wales, Victoria, and so on. To give you an example, the 1981 inquiry in South Australia made 68 recommendations. And the momentum was so great that by 1985, so only 4 years later, 65 of those recommendations had been acted on, and most were either implemented or in the process of being implemented. Mid-1980s, we see the debate on victims' rights manifest at an international level and result in the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. And given the role that was played by the South Australian Attorney General as part of the Australian delegation, he came back to South Australia enthused. I want a similar instrument here in South Australia, and so he introduced the first Declaration of Victims' Rights in Australia, in South Australia. But it was only an administrative direction, no enforceability. It was, if you like, an aspirational document about what they would like government agencies to do to improve the treatment of victims of crime and to empower victims through the provision of information and, in some areas, participation. The other thing of the 1980s, towards the end of that decade, was the growth in victim scholarship. For example, and I mentioned this last night to some people, in 1988, the first subject of victimology at a tertiary institution was introduced in South Australia. And in the same year, it became a compulsory subject for people in the South Australian Police who wanted to become a sergeant or above, and it remains such to this day, a 15-week block unit. And victimological conversations in academic areas began to evolve, so the subject became included in modules, in law degrees and other things. But it's not considered a unique discipline, I need to add that point. Come the 1990s, well, Australia comprises 6 states and 2 mainland territories, and they have different national or federal councils that try to bring about some sense of harmonisation. In the 1990s, one of the outcomes of that attempt to have some form of harmonisation was the introduction of a national charter on victims' rights. Now, a national charter is an agreement between the 9 jurisdictions, the 6 states, the 2 mainland territories, and the federal government about minimum standards or principles to govern the way that victims should be treated. Interestingly, the Australian government, the federal government, to this date does not have a federal charter on victims' rights. Because up until 1990, most federal offences in Australia were victimless in a legal perspective. And it's only since the 1990s, with the introduction of sexual servitude and trafficking in human beings and other matters, sexual exploitation of children, that we've seen federal offences that involve human beings as the direct victims. So that's a matter which is yet to be resolved. Well, there also research began to inform public policy. So for example, one of the things that happened with respect to victim impact statements is that when they began in 1980, they were written by police officers. By the early 1990s, victims could write their own statements, and by 1998, they had the right of elocution, the right to go into a court and read their victim impact statement in front of the judge and other court officials, if that's what they chose to do. We also saw it in the 1990s, increasing government intrusion into victim services. And the most profound debate happened in the area of victim compensation. And so under austerity measures, as well as some ideological questions, governments around Australia began to shift away from the idea of compensation to financial assistance. Financial assistance augmented or complemented by the provision of state-funded therapeutic services. So one state, Victoria, for example, abolished compensation from the state for any form of non-physical injury, and only provided state-funded compensation for physical injury for the purpose of covering the financial expenses or losses. So nothing for the pain and suffering and the anguish that was caused. If you had a non-organic injury, a psychological injury, then the state paid for treatment under the policy position that it was the state's obligation to help someone resume their life, to come back into doing, working and living it as near as practical to the standard they enjoyed before the victimisation. And that debate has continued to rage throughout Australia. In fact, the new federal scheme for assisting victims of terrorism overseas specifically says in the background documents that the payments are not compensation, they are acknowledgement payments by way of financial assistance for victims of terrorism. Come the 2000s, the noughts, we see that there is a conversation about how can we actually improve justice for victims of crime. So we've gone beyond compensation, financial assistance, beyond providing assistance through self-help groups and government-funded therapeutic programs, to starting to look at what can be done to advance victims' procedural engagement, their participatory rights in the criminal justice system. So the mantra was victims should no longer be bystanders in the criminal justice system. Also, we began to acknowledge as a nation that we had 6 states and 2 mainland territories, and victims were treated differently within the one country. For example, today, if there was an act of terrorism in a shopping mall in Adelaide, then every person who was defined as a victim for that incident would be entitled to apply for up to $100,000 compensation from the state. If that happened in New South Wales, the maximum payable to anyone who wasn't injured would be $5,000 Australian dollars. But they would get $20,000 worth of government-funded therapeutic service in addition to that. And there are dramatic differences around Australia. In the Northern Territory and Queensland, you no longer get any form of compensation for your non-organic, your non-physical injury. So it's quite dramatic. So this idea of trying to find harmonisation was brought about, and a national working group was established, and that national working group began to look at a number of issues. And what's more, once again, some of the research done by scholars and others began to inform that debate. On the issue of empowerment, we saw the establishment of independent statutory officers, such as the... Time up, 5 minutes. Okay. Such as the Commissioner for Victims' Rights, the position that I used to occupy, and I won't have a chance to explain that to you. In 2010, the National Working Group that I mentioned to you began to look at how it could implement some of the philosophies that it had identified in its initial report, such as harmonisation of complaint referral, or referral of victims from one jurisdiction to another. So if I'm a tourist from South Australia in Queensland, and I return back to my home in South Australia, then under Queensland law, I can only get access to therapeutic services because the crime happened in that state, unless there's a referral back to a complementary service in South Australia. So we've set up a protocol to assist with that. We also, the introduction of financial assistance for victims of terrorism overseas was introduced and also modified. And as I mentioned before, we saw the commencement the decade before, but now the cementing of the idea that victims are entitled to procedural justice. And we began to see a number of changes. For example, victims used to be told the decision around a charge bargain, and they could comment on the decision. Now, in at least 2 jurisdictions, they must be consulted before that decision is made. In every jurisdiction in Australia, victims can contribute to the decision on whether someone is released on parole or not. So there were a number of steps taken to engage with these people. Most important is that much of the debate since the turn of the century in Australia around victims' rights has been coupled with governments repeatedly focusing on law and order, longer sentences of imprisonment, expanding concepts of what is criminal, and so on. And what many of us in Australia, including myself when I was the Commissioner, argued repeatedly is for a disconnect. That the expansion of victims' rights and the expansion of victim assistance in terms of providing rehabilitation for victims of crime should not be at the expense of those people who presume to be innocent, who become accused, and even who become convicted offenders. And that instead, as this photograph indicates, there should be a parallel system of justice. And the photograph is what happens in Adelaide when you have over a week of 40 degrees Celsius plus temperatures. Our tram lines sometimes buckle. And if you imagine on the left-hand side, that's the journey of the person who becomes the suspect, who becomes the accused, who becomes the guilty person. We've had a focus on their procedural justice and the distributive justice in terms of fairness of the sanction. What we argue in Australia, and have repeatedly argued as advocates and as scholars, is that when we look at trying to ensure that the journey for the victim isn't marred by obstacles and barriers, in other words, we straighten out those tracks to make their journey procedurally just, that you can do that in a parallel way rather than unduly impact on the rights of our citizens who are presumed to be innocent. And to that extent, victims' rights and so-called offenders' rights are joined within the auspices of human rights. Thank you.
Thank you very much, Mr. Martin. The next topic